Hi, I'm Art Caplan. I'm the head of the Division of Medical Ethics at NYU Grossman School of Medicine. Well, in the news quite a bit, as we all know, battles post the Supreme Court decision on Dobbs that overturned Roe versus Wade. What are the impacts of the return to the states of the ability to permit, regulate, restrict, or ban abortions? And there are any number of important cases moving through the Supreme Court review. There's the battle over mifepristone, the abortion pill that many, many women use. Is that something that could be prohibited when states severely restrict the right to have an abortion from the moment of conception? But more recently, we've seen a huge battle break out over Idaho's decision to have a very strict ban on all abortions, and basically saying, with the exception only of the life of the mother, if that is imperiled, against the federal law, which is the Emergency Medical Treatment and Active Labor Act, or EMTALA, that requires doctors to stabilize and treat any patient who gets to an emergency room. So EMTALA has been around a long time as a federal law. There are many emergency rooms that are quite familiar with people coming in who don't have insurance, who can't pay, but they are still obligated. It's the one place in the American healthcare system where if you're running an ER, you at least have to get the patient stabilized before you let them leave. You don't have to treat them long-term, but you have to make sure that whatever health emergency they face is controlled. So Idaho has argued that there's nothing about this federal law that should interfere with the state's right, and I think there are about 12 other states with equally broad bans on abortion. The Attorney General, in arguing before the Supreme Court, said there's nothing about this EMTALA law that was meant or intended to interfere with the state of Idaho's right to say we ban abortions. I completely disagree with that position. The idea that you're going to have women showing up in emergency rooms, and there are not a lot of them, but when they happen, who need treatment to stabilize something that's gone very wrong in a pregnancy, and their lives are at issue, you shouldn't have a situation first where you've got to wait until you're sure they're going to die before you intervene. That is just bad, unprofessional medicine. It's like saying, we'll treat heart attack patients in the ER, but in order to do so, we want to make sure you're really having a heart attack. So when you're almost dead, we'll intervene. We wouldn't put up with that, and we shouldn't in medicine, with our professional ethics obligation to help people who are in dire straits recover. We shouldn't have to wait if we suspect they're in deep trouble or they might die, and the only way to handle that is through an abortion of a pregnancy to stabilize them. Then that has to happen. It just does. The argument that the EMTALA law never really was meant to apply to pregnant women or abortions is also unpersuasive. Seems to me some of the Supreme Court justices weren't sure, but look at the name of the act: Emergency Medical Treatment and Active Labor Act. It's telling you that Congress intended for patients, women who were pregnant and in trouble during their labor and delivery, to get help. And that obviously could extend to situations where, the rare ones, where their lives are in peril, and the only way to handle the situation is to terminate the pregnancy. When you have active labor as part of the name of the law, it seems to me you have to want to be more ideological than legal in trying to interpret whether the federal law trumps or beats or overrides the state law. So my position is, on professional ethics grounds, women in trouble during pregnancy where the only option is to terminate the pregnancy require a rapid, quick response waiting until you think they're going to die, holding them in the parking lot, keeping them hanging around in the emergency room while they suffer. That is barbaric, unprofessional, unethical medicine. And did the federal government intend to tell the states that women who are in active labor need to be helped, stabilized, get the treatment they deserve? Absolutely yes. It's right in the name of the law. So I see no options here to defend complete bans on abortion if women are in peril or if they're having trouble that might require a termination of a pregnancy for whatever reason to protect their health and life. They have a right, I would absolutely insist, under EMTALA to get the treatment they deserve. Would that overturn not only Idaho's complete ban, but other states that are trying to argue that abortion must be prohibited as soon as conception occurs? Yes, it would. But I think that is bad law on the part of the states. There are situations where you've got to put women's health first over that of a embryo, over that of a fetus that is in trouble. I think the full-fledged person has the moral rights that are going to be more significant than the potential person. I'm Art Caplan at the Division of Medical Ethics at NYU School of Medicine. Thanks for watching.